Lieutenant General Dr. Fani. Good afternoon. The last time I greeted you was in the morning, and now it's afternoon. Advocate Zikala.
Thank you, Chair.
I allocate you an hour to conclude the discussion with Dr. Fani. If you go beyond an hour, I can use my discretion to allocate you no less than 20 minutes after an hour. Yeah.
Looking at the final audit report that had been given, just give me a second. I just want to go to the document. So the final audit report is MF11 at page 429 of the annexure bundle. Okay. And then I'm going to ask you to turn to page 447 of that bundle.
I'm at 447.
Thank you. At paragraph 3.3.4, this is now the internal auditors. They say that they have observed the following red flags and or evidence of fronting in the bid of Medicare 24 Tshwane district. And they begin to detail in the paragraphs below why they have indicated that there was fronting in the bid. Can you just begin to read out what is indicated, maybe starting from paragraph 3.3.4.3?
Thank you very much, Honorable Chair. I will read 3.3.4.1, and it says the bidder is a registered company with company registration number. The company was established in 2019. The company was registered and is registered on CSD and was vetted by the National Treasury. I do not have enough information to substantiate why that was an anomaly.
Okay. But, and then now at 3.3.4.3, can you indicate what the internal auditors have indicated about their finding that there was fronting? Their
report says there is only one director of the company who is an African male. The address of the registered office is 103 North Rand Road, Baden-Boksbeek. I don't know how that constitutes fronting.
Yes, I was asking if you could read 3.3.4.3.
Oh, 3.3.4?
0.3, yes.
Thank you, Honorable Chair. The bidder is operating under franchise agreement with the franchisor with its own company registration number. The bidder and the franchisor share the same business address. The bidder did not indicate in the bidding document the third-party supplier arrangement.
What do you understand that to mean?
What I understand this to mean is that in the tendered returnables, there is no evidence that was found by the auditors with regards to an agreement between the two parties. Yes,
but as I read 3.3.4.3, sorry, it's difficult. It's just, they say that when you look at the entity, it is operating under a franchise agreement or tries or purports to operate under a franchise agreement, but that was not indicated in the bidding documents that there would be a third-party supplier. Now, would that be the kind of requirement that would have caused the bidder to be excluded?
We have stipulated in our tender documents that if you are not operating at your premises, you must provide us with the water and lights account, or you must give us an agreement where you have with the person that owns the building. In this instance, it's not just about rental, it is about operating and utilization of facilities in that space. It appears that the bidder did not own the facilities, but has a franchise agreement that was picked up by the auditors.
Yes. But what the auditors indicated 3.3.4.4 is that that franchise agreement was not signed by the franchisee and so could not be relied upon at the time of bidding. So going back to my earlier question, wouldn't that have been a mandatory requirement that had to be complied with in order for this bidder to have progressed?
Right. Let's one, the franchisor signed, the franchisee did not sign, and the document was available. The question that we can then ask is that is 3.3.4.3 being nullified by 3.3.4.4, because 3.3.4.4 says an agreement was there but not signed, and 3.3.3.43 says there was none. So internal audit may have to answer that one. I cannot vouch for any of the statements.
So, but whether there was none or it was not signed, wouldn't in both circumstances it mean that the mandatory requirement was not complied with? Either there was no supplier agreement or there was a supplier agreement that was not signed. But under both circumstances, what I'm asking, doesn't that mean that there was that particular mandatory requirement to show a third-party supplier was not complied with?
The requirement is that there should be one if the bidder is not the owner of the facility. What this 3.3.4.4 seems to suggest is that the franchisee did not sign. What it is not saying is that the franchisor signed and what the nature of the relationship would have been. I would presume that in the clarification, when legal was writing to the bidder, clarifying issues before disqualification, they would have clarified this. I'm not privy to that, but the document must be complete. That's what I'm saying.
Yes.
Yeah.
But what I'm asking you, and maybe I'll ask, what it clearly indicates was that the document wasn't complete.
What it indicates is that the franchisee did not sign, which makes the document not to be complete.
So doesn't that mean that a mandatory requirement wasn't complied with?
It would appear, well, it is not being complied to if the signatures are not complete.
Just to clarify, is that a yes?
It's a yes.
The role in the franchisor and the franchisee, what is the role in the bid? He seems to suggest that maybe the franchisor didn't matter.
Chair, if I may also indicate is that the internal audit had qualified that, if I may read it, the franchise agreement is not signed by the franchisee and cannot be relied upon and was not a requirement at the time of the bidding. That's what this statement is saying. I do not have the document to verify which was the requirement. So it gives two contradictory statements, that sentence that is written there. Maybe they wanted to say and was a requirement, yes. But what is written here says and was not a requirement.
Yes. Can you go to 3.3.4.8? Can you?
The bidder submitted a company profile of Medicare 24 holding and not the third-party supplier's declaration as required by the special conditions of the bid. It should noted that Medicare 24 holding did not bid and therefore their company profile is irrelevant for this bid. By submitting the company profile of the Medicare 24 holdings together with the bidding documents, the bidder assert that the bid will be executed by Medicare 24 without making third parties declaration. The finding is correct.
That finding is correct.
Correct.
In so doing, would that have been a mandatory requirement that was not complied with?
Not mandatory. It was part of the criteria for evaluation.
Can you go to 3.3.4.10?
3.3.4.10, the pricing schedule submitted by the bidder was different from the pricing schedule issued with the original bid documents in that the control numbers on the top of I would assume that it says on top of each page were changed. The SBD 7.2 bid cover page and pricing schedule were submitted for forensic analysis to establish whether they were signed by the same person. The forensic analyst established that the signature of the bidder on SBD 7.2 did not correspond with the signature of the bidder on the submitted pricing schedule. Therefore, the pricing schedule submitted by the bidder could not be relied upon as it lacked integrity.
What does that mean?
The specialists had a look at the signature that was attached to the document. They are specialized. They are specializing in that form. The question that could be asked is, would any reasonable man could have seen that the signatures were not the same? The answer is no.
As I read 3.3.4.10, they say more than just the signatures. They say essentially that the pricing schedule had been tampered with and that it was not the original bid document, I'm reading from the second line, that had the control numbers that were submitted. So, and you can clarify or with me if I'm incorrect, but as I understand it, there are certain forms that have particular control numbers that must be submitted with those original numbers and so on, and the pricing schedule is one such document.
Correct.
And that in this case, that pricing schedule had been tampered with. And so it was not the original numbers or control numbers of those documents that had been used.
It's an audit finding. The BEC should have picked up the format of the document, and indeed, if internal audit picked it up, and it is warranted. One of the tender requirements that we have is that the submitted schedules should not be changed or altered in any form. If they have been altered, this should have been a disqualification.
So this requirement that the pricing schedules that were submitted had been tampered with, this should have resulted in a disqualification.
Correct.
Can you turn to page 450? This is paragraph 3.3.8 of the audit report. Can you read, because it's a long paragraph, can you read the finding just before where they discuss the Treasury regulation?
Right. It is alleged that the bidder committed an unethical conduct in respect of the procurement process in another organs of states, that is Gauteng Provincial Government at Tembisa Hospital. There were allegations of alleged procurement irregularities committed by the Director of Medicare 24 Tshwane District prior the evaluation of the bid. The bid should have taken into the BEC should have taken into consideration the allegations raised on the media about the director to inform their due diligence methodology. The due diligence did not ascertain all facts concerning the bidder, resulting in a material control weakness.
What do you understand the internal auditors to have been flagging there?
All that internal audit is saying is that with the media statements that were made concerning the director of this company, the bid
And this is Mr. Matlala.
that is Mr. Matlala, the bid evaluation committee should have disqualified the company. Let me just clarify what is the correct process. The correct process is that when you evaluate the tenders, you evaluate the tenders as received. In your report, you then highlight the issues that should be considered by the bid adjudication committee. If those concerns that were highlighted by the bid adjudication committee are outside the tender process, the bid adjudication committee will adjudicate the tender. If this supplier becomes the winning bid, the bid adjudication committee will not award that tender. They would have to refer that matter to legal services so that legal services can give direction with regards to what needs to happen with regards to that bid. You do not disqualify any person on other matters that are unrelated to the tender when you do evaluation and when we do adjudication. You highlight those in the report and you make sure that legal services assist you with crafting a report for disqualification of that supplier. Treasury regulations indicate that if for any reason the bidder who has received the highest point, they are not saying disqualified for other reasons, that has received the highest point cannot be appointed, such a bidder, such reasons must be given and such bidder should not be appointed or be awarded a tender. Had we known as bid adjudication committee, I'm not sure to what extent the bid evaluation committee knew about the issue of Mr. Matlala. We would have, as I've indicated in my affidavit, we would have flagged this with legal services, and legal services would have crafted us a reason which justifies why the supplier should not be appointed.
Thank you. Fani, as I read this paragraph, it's maybe making 2 points and to discuss with you. The first point that it makes is that there should have been a due diligence process that picked up the fact that Mr. Matlala was a person who was in the media reported to have been involved with Tembisa Hospital. And that there was a failure in the due diligence process regarding that. What I understand you to be saying is that had you known, you would have gotten a legal report or so on. But can you answer the first question, which is whether there was a failure with the due diligence process, that it should have picked up that this was a bidder who was alleged to have been involved in procurement irregularities in relation to Tembisa Hospital?
Right. Honorable Chair, I wouldn't say there was lack of due diligence done. We rely heavily on information that is recorded for us. In the CSD report, I would refer to page 453. In the CSD report, the CSD report
Yes.
indicates.
Can I indicate that the CSD report is at page 457 of the annexures.
I've got it as 454.
Yeah. Let me just check. You are correct. It starts at 454.
Yes. In the CSD report, this does not talk about Ket Matlala. I'm looking for his name. It talks about Vusumuzi Matlala, but that's
Yes.
immaterial.
That is as I understand it, the name Cat is a nickname.
Yeah.
So I think it is Mr. Matlala.
As I've indicated earlier, I had no knowledge of Vusumuzi Matlala. I may have heard in the news that there's issues at Tembisa, but it for me personally, and probably for other members of the committee, that for us to link him at that time to Tembisa did not happen, and for a reason that it did not appear to us at that time that this person is the person that is being wanted. But importantly to note is that we rely on information we get from CST. The framework that governs restriction of suppliers in government clearly indicates that a department or entity that has experienced any anomaly with regards to the supplier, either in terms of crime committed or in terms of performance of the supplier, initiate the process for restriction. It would appear that based on the CSD report, that such a process was never embarked upon by any department, resulting in this individual or this company being cleared on CSD not to have been restricted. We have also gone to the register of restricted suppliers that National Treasury publish. We have looked for both the directors of the company, and we have looked at the company itself. There is no such a restriction. But I'm just saying, from a procurement process perspective, we have clarified that had we known that this person, Vusumuzi Matlala, or the company that he operates under is suspicious, as I've indicated, we would have flagged it with legal, and legal would have provided us with direction that this is indeed a suspicious transaction that SAPS is about to conclude.
So, and I understand what you're saying. You're saying within the formal government structures, there was no restriction on the company or the person, such that it was not indicated that this was a blacklisted entity,
Yes.
or a restricted entity. That am I correct in that understanding?
You are correct. From both CSD perspective as well as the registers that National Treasury keep, that we look at before we conclude on any tender process.
I guess the question, and as I understand the issue that's being raised by internal audit, is this, though, in the public was an entity or a person that was flagged as having been involved in significant public procurement irregularities at Tembisa Hospital. This was and they have held the view that at least that should have been flagged by the bid evaluation committee. So I'm separating two. The one is the formal registrations that exist on the CSD, but whether, as they indicate here, that considering the extent of the allegations that were in the media, were those allegations completely irrelevant to the tender that was being adjudicated by the SAPS at the time?
I'm unable to answer on behalf of BIC. Certainly on my behalf, I did not find a link, and I'm sure the members of the BAC at the time, otherwise they would have flagged it in the deliberations. I at the time of the adjudication, I did not even try to establish the link because it did not appear in my head that there is a link between this matlala and the matlala that is, or any other matlala for that matter. The assumption that is made is that the bid evaluation committee and the bid adjudication committee ought to have known, and I dispute that.
And maybe just the one last point before I move off this. I think as I read 3.3.8, the comment that is being made by internal audit is not that you ought to have known, but that a proper due diligence ought to have taken place that would have picked up this widely known information.
The procurement due diligence was done. The procurement process cleared the supplier and the director based on the treasury regulations that we need to comply to. Any other form of due diligence that ought to have been done is not part of our process, and I would not speak to it. It is unknown to me.
Okay. So if you turn to page 4.5.1,
is it
451? 451.
Page 451. I'm there. I'm there. Okay.
Okay. The general findings by the internal audit is at 3.4.1.1 that the evaluation process in use is extensively dependent on the use of manual documents, therefore is open to abuse and manipulation. What is your comment on that?
Correct. I have flagged our technology management services for a procurement of technology in order for us to utilize technology. I have indicated in my affidavit that the integrated finance management system that National Treasury is working on for years now should have assisted government in making sure that the manual submission of tenders are eliminated. We are stuck with manual elimination at the moment because IFMS has not been implemented. I have asked technology management services to ask for an exemption at National Treasury so that we can procure a system in order for us to alleviate some of these issues. We have been using another system in our quotation process called Intender. That system has fallen off because of the disputes between SITA and the service provider. So we are back to manual system with regards to that. We are testing on the quotation side a new process on CSD. We will implement it shortly. It's one of the developments that we are doing, but it only deals with the quotation process. The tender process is still manual. For whatever reason, IFMS has not been implemented, and it is impacting on us and how we can fully have an automated process for us to eliminate some of the challenges that we're experiencing at the moment. Until then, we are stuck with the manual process.
At paragraph 3.5.1, the internal auditors say that raise the issue with somebody or a position called a facilitator in the evaluation process. And they say that the role of the facilitator in the bid evaluation committee previously exposed and is continuously exposing SAP's bidding process into corruption risks. And then at 3.5.2, they give two examples of cases where the person or the people who occupied the role of the facilitator was then subsequently being charged with procurement fraud. Can you see that?
I can see 3.5.1.1, 3.5.1.2.
Yes. And those are, as I understand it, examples of previous cases where the person who occupied the position of the facilitator was then subsequently charged with procurement fraud. What is your comment about this finding that the use of the facilitator causes corruption risks in the bidding process?
I'm not sure how internal audit qualified that. The role of a facilitator is not above the role of the chairperson of the bid evaluation committee. The facilitator's responsibility is mainly to be in the position to submit the documents to the members for perusal and to keep the record of the discussions. The role of the chairperson is to ensure that the information, in fact, the role of the chairperson and the role of the members of the BEC is to ensure that the information that is captured on the sheets before they sign, these sheets were signed by members of the BEC indicating the correctness of the information that is submitted. So their role is to ensure that they double check and make sure that the correctness of information that was at their disposal is indeed captured on the sheets and is indeed captured on the report which they have signed. How the role of a facilitator has rendered the process into corruption, we will look into that. I'm not going to dismiss it. I would just want the internal audit to advise me proper so that we can write it off in the processes. However, there needs to be somebody in the process who dishes out the documents and who makes sure that there is record keeping. And that role is done by a facilitator. I'm not sure what we will call that, maybe a typist or a data capturer, but he will still be fulfilling exactly the same functions. What is of concern here is that the role of the chairperson of the bid evaluation committee seems not to have been adequate if you look at the things that happened in the bid evaluation committee. And we need to strengthen that role and make sure that the chairpersons of the bid evaluation committee play the role that they ought to play in making sure that the deliberations of the bid evaluation committee are done in such a nature that there are no audit findings.
Who was the facilitator for this particular bid? I see the list of people. You can find it at 369.
I don't have 269.
369, page 369.
369, oh, okay.
Of the annexure bundle. Who were the facilitators in this evaluation process?
I don't want to say the wrong name. It was Captain Cartwright.
It was Captain Cartwright.
That's right.
Okay. Can you go to the exhibit bundle? It's the small bundle. Let me just find the exact page. Just apologies, I can't seem to find the exact page I'm looking for. Not here. What page is it on? Page 18. Okay. If you go to page 17, or if you go to page, let's start at exhibit 3. It's a Media 24 a News 24 article.
It's page 70, page
If
small
you start
bundle,
at
big bundle
Sorry, if you start at page 11
of the big bundle.
of the exhibit bundle,
Okay.
the small bundle,
You're referring me to page
11.
11. Of the small bundle of,
Yes. You have a
no.
just can you give us a moment?
I received only 2 bundles. No. She gave me the documents way before everybody got here. Yeah, so I did not receive. Thank you very much. I've got the copy, Honorable Chair.
If you can go to page 11. At page 11, this is an article, a recent article, but I think there was an earlier one in relation to this contract. This one is titled Tender Profit Cat Matala rented SAPS Medical Clinic 6 months before the award. Okay.
Okay.
Can you see that?
Yes, I can see that. Thank you.
See that? If you go then to page 17,
Got it?
and there's a heading that says backhand cash. Can you see that?
I've got that.
And then there's a section that has a red line.
Got that?
There's paragraph 1, paragraph 2, paragraph 3. On the 4th paragraph, can you see that?
I see that.
It says that Matlala channeled cash to Captain Brian Cartwright through a proxy company. Cartwright was the facilitator of the tender for the SAP supply chain management. So, can I get your comment on that?
This is a media statement, and as far as I'm concerned, there's a forensic investigation that is done. Some of these things will be clarified by that forensic investigation. I note the statement, but that's as far as I can say.
So, and I understand you saying that this is an allegation that arises from the media statement, but in the internal audit report that had been furnished first in January and then in April, they particularly identified the person who sits as the facilitator as being the corruption risk. Is that correct?
Yes, they have flagged that the person is a corruption risk. And they have also indicated here in the media report that he got the money. If this is proven to be correct, then disciplinary processes must be initiated against this individual. In fact, even criminal charges must be laid against him.
Since the audit report was first, the preliminary one was furnished in January and then the final one in April, what steps has been taken to investigate the allegation that this person who played the role of the facilitator was the corruption risk, or was one of the corruption risks?
That role was given to internal audit to do, and the internal audit subsequently did the audit, and the forensic audit is underway. What I have done on my side is to make sure that this individual does not get appointed in any committee to play this role until such time that his role in this matter has been clarified.
So he remains within the procurement department?
He is within the procurement environment doing administrative duties and all other matters, but not in the tender process.
And then I just want to go back to the audit report. So at 3.6 of the general findings made by internal audit, they say that all bids that had been submitted for this tender did not comply with the administrative and mandatory requirements of the bid and should never have proceeded to phase 2. Can you give me your comment on that?
Sorry, I missed which one you're reading.
I'm reading from the final audit report. I'm back at page 451. Apologies.
Page 451. Okay. All right. Just before I comment on that, the internal audit report said the role of a facilitator, and that's what we are dealing with. It did not speak of Cartwright. It's only the media report that spoke about Cartwright. But we will extrapolate and say that because Cartwright was the one that was playing a role of a facilitator, we need to take precautions and make sure that he does not facilitate until further notice. I just wanted to clarify that one.
Yes, I think that, yeah, that is correct. The internal audit report said that there is a particular role called the facilitator, who has in previous cases already been shown to be a corruption risk, and they flag that as a corruption risk. Subsequently, media reports indicate that the person who may have played the role of the facilitator in this tender received money from Mr. Matala. So yes, that is a deduction. But what I'm asking you and for your comment really is that as early as January and finally in April, this particular role that is played within the procurement environment of SAPS is being flagged as being a massive vulnerability and what gets targeted for corruption. Your comment?
I would, as I've indicated, the role of a facilitator ought to be that of making sure that the documents are provided to the members and making sure that the scoring and documentation of such discussions is updated and is accurately captured. That does not supersede the role of a chairperson who has an overall accountability. And that does not supersede the role of the members of the bid evaluation committee, who must make sure that what they are signing for is indeed what is correct. If for whatever reason that person is dominant in the discussion and in the processes, which it shouldn't be, then we have a challenge with regards to the whole makeup of the bid evaluation committee and the strength and the power that should be exercised by the chairperson of the bid evaluation committee. And I have serious concerns if that's the case. It has been flagged in the report, and we have looked at it in our discussion in August when we had a three-day session with my team to make sure that each committee and how it functions needs to be strengthened so that we do not have repeat audit findings of this nature.
General Fani, at the paragraph 3 of your statement on page 2, you indicated that in preparing for this hearing, you spoke to a number of people, and one of them was General Mkhwanazi.
Yes.
What was that concerning?
Not in preparing for this hearing, in pertaining this matter. Just before I went on college, when Mr. Cartwright's statement was in the media, General Mkhwanazi was looking for a specific report pertaining the same matter, not this matter, but pertaining the whole Madlanga Commission matter, which he wanted from procurement. And then he indicated to me at that time that there's a media statement out which flags Mr. Cartwright, and they are doing further investigations. And based on that, then I took the decision that Mr. Cartwright's involvement in the tender process should be in abeyance until such time that the investigation is complete. That's as far as I have discussed that matter with General Mkhwanazi, and no other discussions on any other matter.
He seems to be saying that will be a problem. You know, the facility couldn't didn't influence it. He's in control of it.
General Fani, I guess what maybe we require clarification is, you say that the facilitator is only there to help shift documents or to be able to move things around. Can you maybe articulate for us one more time what actually is that role of the facilitator that is being flagged here?
Hence, I have indicated, let me clarify what the role is. The role is there's a chairperson and there are end users. And the role of the facilitator is to make sure that they prepare for the BEC evaluations. And they make sure for each stage the documentation is given to the members, and the members peruse the document. And once the members have perused the document and they have finished with the document and there's another document required, and if a decision was taken, the applicable documents that needs to be updated or filled in are filled in, and they are filled in correctly.
So is this the person who is in charge of the documentation, or at least updating the documentation? And unfortunately, to use the same word, facilitating that documentation is provided to the members of the evaluation committee?
The documentation are supposed to be managed by the chairperson of the committee or any person delegated by him who is part of the discussion. I'm not sure what the relationship was between the chairperson and Mr. Cartwright at that time in terms of who managed the documents. But in the meeting, that person will then facilitate the dissemination of information and making sure that the decisions are covered correctly. There should be a scribe that does that, but he must furnish that information to the members of the committee. The chairperson checks the accuracy of the information that is put in the documents after he has also perused the documents, because he's a scoring member of the committee, and making sure that the information is accurate.
So, and I think we will get to this, but both the preliminary and the final report essentially finds that there were certain issues in relation to the documentation of this particular tender. Is that correct?
Correct.
And that would have been or let me ask it as a question, and would that have been the type of documentation that would have been administered or controlled by a person such as a facilitator?
Honorable Chair, as I've indicated, the chairperson of the bid evaluation committee is supposed to fetch the documents from storage and make sure that he keeps guard of the documentation. What we need to establish through a forensic investigation is who handled the documents and how were the documents handled. It does not come out of the reports that are furnished to us. And I would like the forensic audits to go and establish exactly who handled the documents. And if Mr. Cartwright handles the documents and there are issues pertaining to changing and falsification of information, it then justifies the outcome of the audit report. From where I'm sitting, I am not aware who managed the document. I would place that responsibility on the chairperson because that is what is expected of him.
Okay. Thank you. So can I ask that you look at the conclusions of the audit report at 4.3, also on page 451. 4.3.
I'm the Honorable Chair.
Or maybe let's start with 4.2. A significant finding that is made is that absolutely none of the bidders should have actually proceeded towards the next phase of evaluation. Do you agree?
I cannot dispute 4.2.
At 4.3, the internal audit report finds that the BEC, the evaluation committee, did not have the appropriate skill and competency to evaluate the bid. Your comment?
The levels of the members who were at BEC is at the major general level. It's a fairly experienced and fairly senior position in the South African Police Service. In fact, it's 2 levels down from the National Commissioner. The appointment of these members, it is explicitly indicating that they are quite knowledgeable about the process. What is stated in the appointment letter and what is stated in the audit report is concerning. But I'm of the opinion that they were experienced to perform the job that they were performing by virtue of the level they are in and by virtue of the experience they have and by virtue of the number of tender processes they may have dealt with in the past.
Okay. The second sentence in 4.3 says, evidence of individual bid scoring evaluation sheets could not be found in the bidding file. So when the internal auditors went to the files to look for the individual scoring sheets, those could not be found in the files. Your comment?
The methodology that was used by the bid evaluation committee probably was of the fact that they consolidated the discussion, but they are in a best position to attest to how they have used the methodology that they have used.
And so I just want to go back with you over this, your response. The criticism that is being put forward is quite a significant one, that they couldn't even find evidence of the individual bid scoring. The recommendation was then taken to your committee, the bid adjudication committee. Your committee, as I understand it from the delegation of powers, is required to at least satisfy itself that these functions were done and properly done. So insofar as the criticism and the finding from audit is that they could not even find the individual scoring sheets, is that not a significant finding as against not only the bid evaluation committee, but also the committee that eventually made the award?
Honorable Chair, my response to that is that the bid evaluation report has provided us a consolidated report of the members of the bid evaluation committee. And that consolidated report gave us a picture of what were the reasons for disqualification of certain suppliers, not individual score sheet. And that was sufficient enough for us to look at the reasons provided by the bid evaluation committee for disqualification.
General Fani, are the bid evaluation committee members required to give a consolidated report, or are they individually required to score the bids?
It depends on the nature of the tender that we have. For an example, in this instance, they were not scoring. They were looking at compliance. Technical evaluation, you either had that competence or you didn't. And if you had the competence, you would qualify to the next stage. If you didn't have that competence, you would not go. For an example, in this tender, if we had allocated points for each level or for each competence required, and let's say, for instance, that individual does not have a qualified dietitian, if a dietitian was required, and we give them 0, they would, if they get the threshold required for that tender, they would have proceeded without a dietitian, and we need a dietitian. Therefore, in order for us to make sure that all the elements of the SPID are all the requirements for this service are met, every little point on that bid specification ought to have been met. So I'm of the opinion that the committee looked at all the documents and they jointly look at whether these companies have got that. If there were points allocation required, each individual would have had to score their points, because you would have wanted to have an overall point and make sure that the threshold of that specific bidder is met as per the tender that was advertised. There was no threshold indicated in the bid because all attributes were required. Any tender that did not meet any of the attributes ought not to have been pulled into the price and BEE evaluation. I am of the assumption that that's the methodology that they used to look at the tenders and look at whether the tender, but they are in the best position to advise how and what methodology they used with regards to this tender.
But what I'm asking you, because your committee eventually awarded this tender, was whether there was a requirement for individual evaluation or consolidated evaluation. Were there requirements in the bid specifications that would have required individual evaluation?
It's not in the tender process. It is in the tender, the procurement policy of subs speak of into scoring sheets.
Yes. Can I clarify?
Sure.
In terms of the specifications,
Sure.
Were there specific specifications that would have required individual scoring, or was a consolidated in respect of all the specifications sufficient? That's what I'm asking you. Was there in the specifications the type of specifications that would have required individual scoring?
The specification we would not put administrative functions into a bid spec. The functions of the bid evaluation committee are not in the bid spec. They are in the procurement policy. So in the bid specification, there wasn't mention of each member having to score independently, but there is pronouncement in the procurement policy that should happen.
can I just get your clarification? Was there, I get it, not in the specifications or so on, was there an element in the evaluation that would have required individual scoring by the members of the evaluation committee? You indicated in your response now that if there were points that would be, it wasn't a yes/no answer, it was points that had to be allocated, then that would have to be done on an individual basis. I am asking you, was there aspects of this particular bid that would have required individual evaluation?
Not as far as I'm concerned, no.
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 So can you now turn to paragraph 4.5 of the conclusions? Or can we maybe start at paragraph 3.7? Internal audit finds that the bid adjudication committee did not exercise due care in considering the evaluation report of the bid evaluation committee. What is your comment there?
I don't agree.
You don't agree?
I don't agree.
At paragraph 4.5, it then requests, then it states that members of the bid adjudication committee and the bid evaluation committee should be subjected to disciplinary processes for failing to prevent irregular expenditure. Your comment?
Each member will have to go and exonerate themselves in that process.
Can we turn back to your statement, please? So now leaving the audit report, having received these two audit reports, would you agree with me that the findings in the audit report are significant?
Yes, they are.
And would you agree with me that they demonstrate, or at least signify, that there were some significant irregularities in the awarding of this awarding of this particular contract?
Based on based on the issues picked up in the evaluation process, the tender should have not been awarded, yes.
Now, stepping back, where do you believe the errors and flaws occurred, in your opinion?
The issues that are picked up in this report indicate that in our bid evaluation processes, we have deficiencies. We've also acknowledged that there are deficiencies in the meeting that we had with my team, and we need to have tighter controls with regards to that. We also need to get to the point where we have to look at the nominations that we get for members to sit in the bid evaluation committees. We also need to make sure that within the procurement, if there are elements of criminality and there are specific individuals that that have been found in other processes or otherwise, we have to be in the position to manage or deal with that and make sure that there are seamless issues with regards to our procurement. We have already started and embarked on a number of corrective actions that we need to put in place in that process, and we are implementing them at this current moment.
General Fani, in relation to, so you say that you now looking back believe that there were errors and flaws and irregularities, and given that there's a criminal investigation, the possibility of corruption in the bid evaluation process. Would you agree that there may have been, and maybe placing it no higher, deficiencies in the bid, in the processes that were led by you in the bid adjudication committee?
I'm sorry, I didn't get that question.
Yes. So you agree that there may have been errors in the bid evaluation committee, but would you agree that there may have been some errors and flaws in the committee that was chaired by you, the bid adjudication committee?
I wouldn't say that, because if you look at the completeness of the report that was tabled at the bid adjudication committee, it was complete to a point that it was easy to even adjudicate on that tender. What we are looking for, as I have indicated earlier, is the flow from a procurement perspective, procurement process perspective of events, and from the bid specification perspective, we also have looked at the flow, and the flow indicated in the report that everything was in order. What we've also looked at was where the grounds for disqualification of suppliers justified, if you look at what was contained in the bid specification, and we have established that they were justified. What was not indicated, that there was an omission that advanced the suppliers forward to the next level of, is something that we could not detect. You have mentioned that we've indicated that there was corruption. In the procurement process cannot detect corruption. It just makes sure that the process is fair, transparent, and that if there are elements of corruption that are apparent, we will then be in the position to expose those. But in terms of detection of corruption, which may have happened outside of the procurement process, we might not be able to detect that. But we are applying our mind to make sure that what has been advertised as a tender and what has been provided in terms of the evaluation report to us is indeed, they are indeed mirroring. And we have done that, and we have done the due diligence as the bid adjudication committee.
Yes. And maybe let me put this to you, because it's in my mind and I would like to be able to get your view. Your evidence in relation to the bid adjudication committee was that they considered the report, and on the basis of the report they were given, that they felt satisfied that it was sufficient. You say that there was no independent verification that the bid adjudication committee did. It didn't call for more documents. It didn't ask to see what was underlying the report. It looked at the report and satisfied itself only by looking at the report. If the criticism is made to the bid adjudication committee that it was no more than a rubber stamp, what would your comment be to that?
I have tried and demonstrate that in other matters, we have indeed demonstrated that we are not just rubber stamping. We do look at the attributes of other things that needs to happen. In this tender specifically, we have received information. What we also rely on, which I should not take away, is the quality criteria that is embedded in the process. The verification of the source source documents is done within the procurement environment, and they sign to satisfy that they have looked at the information and it is to their satisfaction. What we then have to do when we pick up an anomaly, we would go and probe on that anomaly. For an example, when this tender came to us the first time, we did not adjudicate because the validity of the tenders was questionable. So we referred it back until that validity was done. And only when we were comfortable that validity was okay, we adjudicated the tender. So we do look at other things that are critically important with regards to the adjudication process.
Can I ask this? Doesn't the process that you outline at least highlight this vulnerability? It is easy to manipulate the bid adjudication committee because all you have to do is ensure that you don't highlight the anomaly in the report, because it doesn't then pick up that there's an anomaly. If the report doesn't highlight the anomaly and it sits outside the report and is in the bid documents, the bid adjudication committee itself does not exercise an independent mind, does not itself do any independent checks, and therefore it would never be able to pick up any anomalies in the adjudication process. Your comment?
Honorable Chair, we have since put together a property audit team to assist us with looking and verifying that suppliers that are advanced have been advanced correctly, and that they should not have been disqualified, so that the process of adjudication is done in a seamless way. If we were to verify each and every document that we have received, as I've indicated earlier, it will become a cumbersome process. The property audits will then assist us in terms of making sure that they validate that indeed the processes that we did, that the BEC went on or embarked upon, were indeed above board. You are correct in your deduction. We have picked up that, and we have put corrective measures in place to make sure that there's a property auditors from the internal audit department between the bid evaluation and the bid adjudication committee to pick up any anomalies that could not have been transparent in the process. It then also has indicated to us that the quality assurance processes that we have put in place are not serving us as a bid adjudication committee, because they ought to have picked up these anomalies, but they did not. And therefore, we needed to put in place another measure, and we have put that measure in place with immediate effect.
And this may be my second to last question. As I understand it, what you're telling the public and what you're telling the committee is these are forward-looking measures that you have put into place. But as at the time of this adjudication, if the flaw was not in the report, it would not have been picked up by your committee.
Absolutely. I tried to find a way to reason this in a scientific manner. And the closest I can explain how some of these things could have gone through was in a bank environment. Was in a bank environment. The teller had no means to determine whether the note was a fake or not. And lifting up in the air was not sufficient for them to do that. And a machine was introduced to look at those things, to eliminate the issue of fake notes that goes into the banking system. And what we have done now, in the absence of technology, we've got the probity audits that are in place. But I have indicated that for us to have a solid and seamless process, we need to have a technology that will assist us with regards to making sure that some of these things are rooted out of the process.
Thank you, General Fani. I made an undertaking that was my second to last question, so this is my last question. Can you, you have set out your views in your conclusion. I don't know if there's any of that you want to be able to to read to the committee or set out and
Honorable Chair, I have indicated that the things that we will look forward to, they are on page 30 and page 31. We are looking at making sure that we've got a seamless procurement within the South African Police Service, and we are working tirelessly with Internal Audit and Risk and Assurance Committee to make sure that we implement these measures. We have a working document with my team that we are implementing, and we are hoping that we will be in the position to do this. The issue of these contracts, this is the only contract in my entire career that was cancelled under my authority, and I take it as a serious concern that at least in the last 32 years of my working life, I have one contract that was cancelled. I wanted to leave the service with 0 contracts that do that, and I will work tirelessly to make sure that the controls are in place. Together with internal audit, we will make sure that we are okay with regards to the tender processes. Thank you, Chair.
Chair, that would be the witness's evidence in chief. Thank you.
I'm giving you a standing ovation. Honorable members, can we applaud her? We are very proud of you. Next time, if you need any kennisgeving, you can mention the name of Honorable Shongwe, Honorable James, Honorable Sokanyile, Honorable Nomvalo, Honorable Breitenbach, Honorable Kola Barnett, and say they know me. And we will never forget this moment. That the parliament of your country has given you an opportunity to lead evidence here, and you did it very magnificently. We are very proud of you, and we hope that you will keep the standard. You must not grow feathers, and you must not grow horns. Just continue to serve to your abilities. This was splendid. 8 Sonnerlek. Honorable members, it's now 15:24. We are starting at 15:30. And the first speaker here is going to be Honorable Skosana. He has made a request to me that we may have to bring him earlier on the list of speakers. We are allocating 20 minutes per speaker, and that is inclusive of the responses. And we follow the same approach that we followed yesterday. We don't take follow-up questions in between the questions and the responses until all of us are done. And the chairperson has declared yesterday that he is not a time storage. There is nobody who is going to be allowed to use half of a time and say, I'm going to come back. If we give you 20 minutes and you finish in 5 minutes, the 15 minutes are no longer usable or reusable. Who else wants to come after Honorable Skosana, or is it only you? Is it you, Breitenbach? Okay, we will take Honorable Skosana, then we will take you, and then we will go to Honorable Ngola and Honorable Sokanyile. Honorable I want you to start at past.
Start now.
Okay, thank you.
Thank you, Chair.
Dr. Fani, thank you so much. We have come to the end of presentation of evidence. We are now at a point where, or at a phase where honorable members are going to ask you questions. And then you will respond to the best of your abilities. Are we okay?
I'm okay, Honorable Chair.
Yeah, I think we came back at 14 hours. We normally run for 3 hours and take a break. But at any time you feel like you want a comfort break, you can always indicate to the chair.
I've been drinking a lot of water. May I take 1 minute and then
Okay.
come back? Thank you, Chair.